Kia ora koutou, greetings to you all from Aotearoa, New Zealand. I'm so pleased to have been invited to present today by the Equality Rights Project. So my thanks to Cherry and to the project. Thank you also to Puja Kapai for very kindly agreeing to be the discussant today. Kapai actually means good job in Te Reo Māori, our Indigenous language here. So I really like your name. It would have been really lovely, of course, to have been with you all in person. I have very fond memories of 2 summers that I spent in Hong Kong as a law clerk. So I'm presenting today, as Cherry has said, on a paper that was published in 2022, which of course means I finished drafting it quite some time ago, because especially during the pandemic, the publication process has really been quite drawn out. So it's always really interesting and an honor indeed to have a chance to talk about a piece of work after having quite some time of a break from thinking about it. So in preparing for today, I cast my mind back to the very beginning of the project. And I was thinking about what motivated me. What we see on the next slide is that my interest really began with an observation, which is that the term dignity is frequently being used in Anglophone jurisdictions around the world by courts in judgments in relation to crimes of sexual violence. And you see that just in this very small sample that is up on the slide right now. We see here quotes from judicial decisions from Canada describing sexual assault as an assault upon human dignity, from the International Criminal Tribunal for Rwanda describing rape as a violation of personal dignity, and from the Supreme Court of India describing sexual violence as a blow to honor, self-esteem, and dignity. And I think what we're seeing here is courts attempting to describe something that's very difficult to describe, the harms and the wrongfulness of rape, and then using dignity to do that, an assault upon dignity, a violation of dignity, an offense against dignity. I should say, just as before we go any further, just as an aside here, when I refer in the paper and in my discussion today to the crime of rape, of course, that is a shorthand. Many jurisdictions no longer use the term rape. Some, like New Zealand, do retain the term in our criminal code, but it's retained specifically as a penile vaginal offence, one type of a broader range of sexual violation offences. Anyway, returning to these quotes, of course, the word that is common here is dignity, a concept that has famously been decried as being so broad as to be utterly meaningless. It can mean whatever you want it to. Arthur Schopenhauer described it as the shibboleth of perplexed and empty-headed moralists. And just turning to the next slide, I think this will really reinforce this point. And hopefully what I'm trying to do here is create in us all a healthy degree of skepticism about the idea of sexual dignity. I think a skeptical starting point is useful for the discussion. And we see here on these headlines, we see sexual dignity being used in far-right conservative American media to decry progressive liberal views on pornography. So there's an understanding of dignity as something that is societal and communal and is threatened by pornography. We also see headlines relating to a Moscow murder in which the defendant justified his actions by saying that his dignity had been diminished by his female sexual partner. And we also see a picture from India where sexual dignity was used as the rallying cry for a mass march of sexual violence survivors. So it's very clear that sexual dignity does not have an established meaning. And of course, the same is true for the term dignity more generally. And yet, despite that, as I said, dignity is very commonly used in the context of rape and sexual violation. And I wanted to dive into that in a little bit more detail. As my research explores and as I'll give some examples today, dignity is frequently being used by judges around the world in sexual violence decisions, and it's serving various functions which I think warrant closer scrutiny. And indeed, that's where my interest in this topic was sparked, from the observation that dignity is a remarkably prominent concept, not only in debates on sexuality and sexism and sexual harassment and sex, but also in the law of sexual violence specifically. And of course, descriptively, we can say there's probably a very straightforward reason for that prevalence, which is that dignity talk seems to be seeping, carrying through from the human rights legal context to other legal contexts, not just criminal law and sexual violence, but also others. And I just recently wrote a paper with one of my colleagues here at Otago on all of the different ways that dignity is being used as a legal concept in the New Zealand jurisdiction. But regardless of which context it's being used in, we need to acknowledge that there are these really deep debates and reservations and valid questions about the utility of dignity as a legal value. There are concerns about indeterminacy, and those concerns suggest that dignity should be closely scrutinized, particularly when, as I've noticed has been happening in sexual violence, it's becoming a really, really common concept, and also a concept that does real doctrinal heavy lifting in some cases. So that's really what I set out to do in this article, to consider in depth how it is that judges are using the concept of dignity in relation to sexual violence. How are they using the concept? And that's what I'm referring to as sexual dignity. And that's something that had not really been systematically reviewed before. So that's more of a descriptive inquiry, but also I wanted to think about what the doctrinal implications might be of deploying dignity in this particular context. So if we just stay on this slide for a moment, because this slide sort of helps contextualize the inquiry, I just want to talk for a moment about dignity more generally. So there's a wealth of scholarship, debate and commentary on dignity as a philosophical concept and as a legal concept. And as I've already mentioned, it's very much contested. It's commonly criticized and critiqued as being too capacious to do any real theoretical work. But despite that, important body of concern and critique, the normative pulling power of dignity is remarkable. As a normative concept, dignity is very prominent. It's emerged really in the second half of the 20th century in response to the horrors of World War II. It's really emerged as the hallmark of international human rights law. It's been invoked in key social and political movements around the world, including the movement against Nazi ideology in Europe, systemic racism in America, and global poverty. It's incorporated into the constitutional texts of numerous jurisdictions, including Germany, Israel, and South Africa, and even courts in jurisdictions like the US, where the constitutional text does not have any express reference to dignity. Nonetheless, courts, even up to the Supreme Court, are frequently drawing on the concept as a framework for evaluating a diverse range of civil freedoms. So in other words, what all this suggests is that despite ongoing contests about the meaning of dignity and its implications, the moral authority of dignity seems to be pretty well settled, which might explain in part why it's so appealing to judges as an expressive tool. It brings moral authority and weight. So if we can just move to the next slide. Thank you, Claudia. My first objective in writing this paper was to describe this thing that I had noticed, to explore and really map the use of dignity as a value protected by sexual violence laws. And just on the next slide, if we can. just got a little summary of the kind of overview of the research project. So while that's coming up, I'll just continue to talk to that. So my primary method was to really build an empirical view of dignity in rape law around the world in these Anglophone jurisdictions by reviewing cases from around the common law world that use dignity in this particular context. And I'll talk more about those empirical results in a moment. But of course, I also wanted to think critically about whatever results emerged. But before I turned to the empirical results, I needed to, thank you, that was the slide I needed, thank you. Before I turned to the empirical results, I just needed to establish a framework to structure the review and analysis. So I first began by considering the role that dignity plays in feminist sexual violence theory. And this survey of feminist theory led me to see an emerging consensus on sexual dignity in this particular context. And we might call this a particular conception of dignity that seems to dominate the feminist sexual violence discourse. It's certainly not the only possible conception. And my approach here was really inductive in that I was trying to identify key patterns of dignity-related argument in feminist sexual violence theory. And those patterns suggested that there is emerging consensus as to the parameters of sexual dignity. So I was able in this part of the paper to set out a provisional theory of sexual dignity as my framework, which is what I've summarized on this slide. So for example, I discussed how feminist theory rejects sexual dignity as merely reputation or honor. It might encompass that for some people, but for dignity to be equated solely with reputation or honor would be a very patriarchal, limited conception of dignity, and one that I think would objectify women's bodies as sites of harm done to men's honor. It also reproduces a sexual normative hierarchy in which the quote unquote dishonorable woman, the unchaste woman, the gay woman, the deviant woman, the normative other can be exiled as non-dignified. Another feature of sexual dignity in feminist theory is its capaciousness in terms of expressing the multiplicity of rape's wrongfulness more broadly, I think, than the concept of autonomy alone can do. When a victim is raped and her autonomy over her body is denied, there is also a message of degradation and dehumanization and objectification, the sheer use of another as a means to an end. That message is inherent in the denial of autonomy, and the language of dignity is used to express this in feminist theory. The third point on the slide is that we see dignity in the theory being constructed as something equal and permanent. So if you think about the idea of dignity as honor, well, that can be lost, and rape victims can be stigmatized as damaged goods, but dignity as selfhood assumes that there is something inherent and permanent, and that inheres equally in all people. And then finally, I also discuss, and I'm just sort of breezing over some of these quite quickly in the interest of time, but there's a much lengthier discussion on all of these points in the paper if you're interested. The fourth point there is that dignity can be used to frame both individual and communal dimensions of rape's harms. So in the remaining time, and we can move to the next slide at this point, please, I just want to dip briefly into those empirical results and give a few examples of some of the themes that came through in the data. So the jurisdictions that I surveyed looking for cases that are using dignity included Australia, Canada, the ECHR, India, New Zealand, South Africa, the UK, and the USA. And I was focusing on cases where dignity occurred within the same paragraph as either terms like rape or sexual and then narrowing it down to look at the cases where that were relevant to the analysis. Before I go further, I will say that Hong Kong was excluded from the analysis because I did not include jurisdictions with populations under 10 million just due to resource constraints. There are some African judgments from countries with a small population that are included on the basis of being cited in the South African jurisprudence. And I did include New Zealand due to my own affiliation. Okay, so we can move to the next slide now. Thank you. So first, what were some of the themes that came through in the analysis? So first, the normative authority of dignity was illustrated by its recurring frequent use as a means of emphasizing the gravity of rape, particularly in sentencing decisions. Often it was just passing reference, but in some cases there was useful explication. So, for example, if you look at the quotes on this slide, the first discusses sexual violence as a serious blow to her supreme honor, offending her self-esteem and dignity, degrades and humiliates, and leaves a scar on a woman's most cherished possession, her reputation, dignity, and chastity. So you can see this quote clearly shows a dignity as honor approach. And one of my conclusions is that if judges are going to be engaging in dignity talk, then we need to acknowledge that there's potential for harm. I think that the conception here is potentially a harmful conception of dignity. The idea that it's something that is irreversibly damaged by rape. I think that is a framing which might be helpful or resonate with some victims, but I also have concerns that it's a conception that could really reproduce the stigmatization of rape victims. When you compare that to the lower two quotes, they more so focus on dignity as selfhood, which is something that's denied when a person is raped by that process of objectification. Not to say it's destroyed, but that it is denied. So we see the discussion of rape as an affront to the dignity of its victims, treating them as an object and negating their human dignity. And I think that those represent a much more expansive and helpful notion of dignity that more resonates with the feminist theory that I set out earlier. On the next slide is a very well-known reference to dignity. This is from Judge Wilner's dissenting opinion in the Rusk decision, which is commonly taught in US law schools and possibly in other jurisdictions as well. It pertains to the resistance requirement. And I think dignity here seems to be used for its rhetorical power as a way of emphasizing what it is that is at stake when rape law fails to meaningfully protect autonomy. There's not necessarily a distinction drawn between dignity and autonomy, but again, I think dignity is serving an expressive function here. That nexus between autonomy and dignity is something, again, that I discuss in more length in the paper, and it's been addressed in a number of really significant upper court decisions, including from New Zealand, Australia, and Europe. And of course, in the equally famous Canadian Supreme Court case of Yu and Chuck, where the court said having control over who touches one's body and how lies at the core of human dignity and autonomy. Just on the next slide, we again see many judges spoke of dignity as being irreparably destroyed, shattered, or buried by sexual violence. And I discuss in the paper how the idea that dignity can be destroyed suggests a thin conception of dignity as something impermanent, such as reputation or honor, something that can kind of wax and wane and be taken away. But by contrast, I noticed in other cases judges avoided that language and they instead discussed dignity as something permanent and inviolable. And these cases express dignity as associated with personhood and non-objectification. So they often use terms like affront to dignity or disregard or attempt to deny, as opposed to destroyed, shattered, and buried. And I think that raises really interesting questions about, well, first of all, who these judgments are speaking to. It might change what we are emphasizing, but also that broader question about the permanence of dignity, which is associated, as I said, with a thicker understanding of dignity as personhood rather than dignity as honor. And I think that permanence is expressed really clearly here in the quote up on the slide, which is from the US Ninth Circuit. This was a case dealing with the harm of taking sexually exploitative photos of children. And I think it's a very powerful quote. So just to read it, we say that the court notes that the pornographic photographer subordinates the humanity of his subject to the sexuality of the subject. But the humanity of the subject is not eliminated. How could it be? And I think that's a really kind of expressed discussion, again, of this idea of permanence, which, again, resonated quite clearly with a feminist, thicker conception of dignity. And then finally, again, in this very brief review of some of the key observations on the next slide, a discussion of the communal and gendered dimensions also came through in a lot of the cases. So if dignity is permanent and contingent on humanity rather than our reputation or our chastity or our virtue, then it also goes hand in hand with dignity being inherent in all people by virtue of the personhood, regardless of external factors such as race, orientation, or occupation. In other words, dignity inheres equally in all. And again, this was a conception that was really emphasized and expressed very powerfully in a number of cases dealing with minorities. So this Canadian case involved the sexual violation of an Indigenous sex worker who died from her injuries. And we see expressed discussion that she was equally entitled to the law's full protection, equally entitled to be treated with dignity, humanity, and respect, regardless of any other characteristics, regardless of her work. Her life mattered. She was valued, important, and loved. Her status as an Indigenous woman who performed sex work did not change any of that in the slightest. And there were a whole series of cases like this where courts emphasized the equality dimension of dignity to refute arguments that certain types of victims, such as sex workers, are less impacted somehow by the crime of rape or sexual assault. So moving on to the next slide, which might be my last one actually, what lessons can we draw from this inquiry into judicial dignity talk in the context of rape? Well, it's obvious, I think, that dignity is not the only way to talk about the ethical wrong of rape. There's no, and likewise, there's no universal experience of the harms of rape. So as Anne Cahill has noted, any attempt at ethical universalism, so trying to identify the real wrong of rape as dignity or autonomy, such attempts would belie the multiplicity of rape as an embodied experience. But I do think that multiplicity is well served by the language of dignity. I think I see potential and instances of this in the data for dignity to be really powerfully expressive because of its capaciousness. And I think that expressive function is important because judgments have narrative power for victims, for offenders, and for society. So in judgments, judges are using language, including dignity, to try to mediate the experience of sexual assault. And as I've explored, I think sometimes that can be done in a harmful way, such as by reifying and reproducing harmful stereotypes and assumptions and stigma. But in some instances, I think dignity is used in a way that seems to be helpful for validating the lived diverse experiences of rape victims, and also for broadening our understanding of legal concepts such as consent. So I think sexual dignity is potentially a very powerful and productive concept for conveying the multiple and various impacts that rape can have, both on individuals, but also at a communal level on groups. So I discuss how I think that's sort of a validating, expressive function of sexual dignity. And it came through, it was very common in relation to typical cases of sexual violence. The concern, though, is that it's also possible, sorry, not the concern, I should say, but to add to that, it's also possible to imagine less typical scenarios where a dignity or objectification framing is not only useful for describing the wrong, but also necessary for articulating the ethical wrong of non-consensual sex. And I give the example in my paper, it's actually John Gardner's example of sex with a non-autonomous person. So consider the example of intentional sexual intercourse with a permanently comatose patient who's not capable of exercising autonomy and is also incapable of coming to learn of the violation. Now, of course, the law rightly recognizes that as rape. So we don't need dignity to do any doctrinal work for us. But in the thought experiment, I think you can argue that the reason the absence of consent renders the contact wrongful is not because the person's autonomy is being disregarded, but because dignity in the sense of personhood, the right not to be treated as a mere means to an end, is being denied. And then my final point, which is about the last sort of 2 point, the risks, I guess, the second main bullet point on this slide, is that despite all of the potential for dignity to do expressive and even doctrinal work, I still have some reservations and skepticism. It can be useful for framing the ethical wrong of rape, but it's also important that I'm talking about a context, rape, where dignity and autonomy interests would seem to coincide. But what are the implications of dignity in cases of consensual but purportedly undignified sex? For example, prostitution, sadomasochistic behavior, pornography. There's a risk, I think, that a discourse of sexual dignity could be used to justify a moralistic preoccupation with dignity as honor or dignity as respect, abstracted from autonomy, possibly resulting in situations where consent to allegedly undignified behavior is deemed to be irrelevant. And in other words, dignity could be used to trump sexual autonomy, including the choice to debase oneself. And that would have implications for the legal regulation of consensual but non-normative sexual behavior. So in other words, unthinking allegiance to sexual dignity forged in the easy context of rape law might have other consequences in situations where dignity and autonomy can be seen as clashing. And that would have implications for minority sexual rights and for non-normative sexual behavior. So I end the paper by arguing that we need to be cautious and we need to be critical, because uncritical participation in dignity talk, I think, could be harmful. So it's that very capaciousness of dignity that comes with pitfalls. At the same time, I think I'm a dignity realist, given its malleability, given its expressive function and its normative pulling power. I think judges and lawmakers will continue to use dignity in this context. I'm not arguing that they necessarily should, or that nothing but dignity will do, but just simply that given dignity talk is being done, we should attempt to do it thoughtfully rather than perpetuating empty-headed moralism in sexual violence law. And with that, I think my time is up, and thank you so much for listening, and I'll look forward to hearing Puja's comments.
So much, Anna. It's really such an honor to be a discussant to your paper, especially because I think that it really encapsulates a very important dimension of the ongoing debate around dignity more broadly, which you allude to in your paper and you also spoke about earlier. And I think that, you know, the work that you've done in so meticulously kind of piecing together the feminist theoretical framework underlying sort of the approach to sexual violence and how we think about it, but also sort of tying that in together with the empirical work in relation to the contributions emanating from sort of jurisprudence. It's really, really valuable. And I think it's such an important contribution in helping tease out the complexities and the intricacies of the language devices used in the law to formulate wrongs and harms. And not just that, but also I think, as you allude to, the multifarious impact of legal language, not only on the lives or the lived realities of those impacted, but also the impact that such legal narratives can have on societal and legal discourse. So, you know, thank you so much, first of all, for such an important contribution to the discourse on dignity. I also think it's a tremendously powerful approach, given the meticulousness with which you've undertaken the study, to really help clarify and reorient the foundational principles and arguments underlying sort of the criminalization of various harms in the context of sexual violence. But also I feel that it has potential implications for other areas of law. And I say it as essentially coming to this work of dignity as a scholar who looks at offensive speech and its nexus with hate speech and hate crime as part of the spectrum of harms in relation to race, religion, or other minority groups. So I've really sort of been examining how dignity is understood and used as a device in that particular context. And reading your paper, you know, and hearing you share about the different conceptualizations of dignity and sort of the utility of it, I think has been very helpful. At least in that sphere of offensive speech, for example, one of the challenges has been the subjective understanding or impact of the harm as it pertains to the victim, and the capacity of the law, or perhaps the incapacity, I should say, of the law to respond to this inherent multiplicity in that experience of living with hate as an individual, but also as a member of a collective. And so that's something that really struck out at me as perhaps being in conversation with your argument that sexual dignity has this capaciousness and this ability to retain simultaneously this multiplicity, right, in the experience of the harm of rape. And I was thinking about it in terms of how does that apply given the challenges of multiplicity inherent in the harm of hate speech, for example, right? So I'll start out with what I feel is very useful in terms of this device of sexual dignity that you've outlined. I think you've very clearly articulated, especially through the 4 dimensions that you've set up using sort of the feminist theory. It's very helpful that you articulate this framework and map it against sort of, you know, the historical context. And I also particularly found it helpful that you're looking at this from a lens of the opening up of dignity as something that is gradually democratized over time. You didn't have a time to speak the chance to sort of talk about it just now, but I think that you know, looking at how dignity was reserved as an aspect of status that attached to particular individuals in society, and how that has evolved historically to now attach not only to sort of landowning white men, but beyond that now to women as a group. And then more broadly, as a result of World War II, as you alluded, to anybody, you know, by virtue of their being human. And then finally, when you contextualize this evolution in both feminist theory on sexual violence, but also against the construct of dignity as used in jurisprudence in a range of common law contexts, I think you illustrate very well how sexual dignity is able to capture this wide spectrum of the victim's experience of the harm, but also what it connotes, not just at the individual level, but also at the sort of societal and communal level. But again, emphasizing the importance of sort of legal language in kind of using this discourse or this discursive space. So in all, I very much agree with your conclusion as well, especially alluding to the 2 case illustrations that you do, that sexual dignity can be very useful and can be, you know, have this potential for opening up this space to an evolving conceptualization of harm perpetrated in the context of sexual violence. It can be productive, but also that there is this ambiguity which can lend itself to potential dangers, as you've articulated. I also found that there's a productiveness that can be harnessed in relation to the discourse around victimhood and survivorhood. And I'll come to that in a moment as well. But building on this foundational sketch of sexual dignity as a device, I'm still pondering about a couple of things. So the first is how it interacts with various conceptions of dignity as we've come to understand it, and what happens when these conceptions overlap or become simultaneously relevant. So I know you said that, for example, sexual dignity does not necessarily do away with the notion of dignity as honor or reputation. It encompasses it. But I'm thinking within this sort of four-dimensional conceptualization of sexual dignity, is there a more dominant dimension that plays out at any given moment or in any given context? Right, and I wanted to use Christopher Caxor's articulation of three dimensions of dignity broadly. He speaks of dignity as intrinsic, dignity as attributed, and then dignity as flourishing. And as I'm sure, I think you've alluded to this in your paper as well, when you talk about the zero-sum approach to thinking about different dimensions of dignity. These dimensions are not mutually exclusive, but rather they coexist, and they inhere simultaneously in relation to the subject of dignity. So whoever is sort of in that moment, sort of the subject of the conversation of being the person in whom dignity inheres, all of these dimensions play out. But which of these dimensions are dominant, I think, depends on sort of the context. And I think all three carry a subjective and objective dimension of dignity. And so in one sense, it seems similar to the notion of dignity as attributed or perceived, or shares a nexus with notions of dignity as honor or reputation. Because the notions of dignity as flourishing or even intrinsic dignity, I think, are both linked with particular human goods or human freedoms, right? So I find this inextricability of these various dimensions of dignity as sort of sitting at the center of this big question mark of who's deploying this device and to what end, right? And so this subjective dimension that I alluded to, for example, in the context of realizing the harm of hate speech, can be harnessed through the use of the term sexual dignity, in that it goes beyond the notion of honor and links more closely perhaps with the context of the concept of dignity as flourishing. And I think for a victim, for example, it captures, or it could capture potentially the intactness of the victim's self-conception or selfhood in terms of sexual dignity, despite the harm that the perpetrator has tried to inflict. It can also provide an empowering foothold in how the experience of the victim is characterized for him or her personally, but also through that experience of power in the eyes of the law and society more broadly. So used in this way, dignity can be potentially liberating, right? It can liberate the individual from the harm that is sought to be inflicted, and freeing the victim of this attempted sort of harm or degradation in relation to their bodily integrity and beyond sort of the psychological, emotional, communal aspects of the wrong that are perpetrated. I think dignity carries this future forward-looking potential of perhaps rehabilitation and empowerment, and also in terms of educating society to kind of move away from the stigmatizing impacts of harm, of the harm of rape, as sort of inhering in the victim themselves. However, in any given context, dignity may not necessarily mean just one of these dimensions, right? And also it's further complicated by the cultural context in which dignity is sort of being understood or studied or examined. And so it's as much about the intrinsic and permanent dignity and equal worth as it is about the attributed or perceived dignity, as it is about human flourishing, because I think these are really tied in very closely together. And so invariably, sexual dignity as a device will continue to have these appendages, as again, I'm sure you recognize, given your concerns about how this could potentially unravel some of the advantages that this device brings. So how do we see this construct then as being useful in moving away from the more essentializing or invisibilizing tendencies that you alluded to, in terms of the gendered nature of rape? Or how do we protect it against being weaponized as a threat to the normative other, as these are some of the likely pitfalls of this discursive space, as you sort of discussed earlier, is there a way to curate this sort of discursive space more carefully or more meticulously? So I guess my question is whether dignity, sexual dignity, needs to be imbued with a more concrete baseline. So whilst its capaciousness is sort of one of its advantages, is it possible to imbue it with a singular dimension, or argue that there is a particular dominant dimension that's less prone to lending itself to some of these unwarranted or dangerous tendencies? And the second aspect that's of interest to me is the use of rape as a weapon, but also as a message, right? So you again allude to sort of the use of rape in warfare in your article, and how its aim is total destruction and annihilation, and it operates both at the individual and the communal level of harm. And in fact, historically, rape has always been understood to have this dual function. We see rape as not just physical, but calculated as an act to undermine, overbear, the individual, but also it has this inextricable nexus with the power of overbearing and diminishing the spirit and soul or essence of a person, or at least attempting to do so. And by extension, the family, the community, the clan, etc. And so I'm here very much concerned with the cultural or societal connotations there, where rape is deliberately deployed because of its known capacities for inflicting both the individual and communal level of harm. And so it's the societal understanding of sexual dignity that gives fuel to this act as having the meaning that it does, right? And so I really like the example that you draw on in terms of Maori culture and the notion of collective harm. But one of the things I was thinking was that the trigger for communal harm is different in each context. And so culturally, in the Maori context, for example, it's broader and connects with this more universal conception of harm to dignity as being a moral wrong that is impacting not just the individual, but also humanity as a broader collective. But in other cultural contexts, this collective harm is experienced at the group level, and it's personal to that clan group, whether it's ethnic, religious, gendered, or othered. So in this sense, sexual dignity, again, brings in with it these notions of honor, reputation, chastity. So it's got this baggage, basically, that's attached with the historical conceptualizations of sex and rape as acts that are perceived in a particular way in given social contexts. And they carry certain parameters depending on the actors engaged. So I'm thinking here about caste, religion, sexuality, and other minority status. So again, it brings me back to this question that I have coming away from sort of the complexities articulated in your framing, whether we need to imbue sexual dignity with a more humanitarian lens as being the dominant dimension that strips rape of this power of messaging, its messaging capacity in relation to the diminishment of victims or societies or their affiliates, for example, because they invariably sort of cannibalize the fuel, right, that rape sort of has in terms of connotations on dignity as honor. So I'll just sort of stop there and see if you have any responses to that. Thank you so much again, Anna.
Thank you so much, Puja. Those are such insightful and helpful comments, and I really, really appreciate your perspective. I'm actually quite keen to leave time for the chat. I think I could probably talk for another half hour just about everything you've raised. But just to quickly say, one of the things you said is, is there space for curating this discursive space, which I think unintentionally goes straight to the kind of insecurities that I have as an academic, which is, are we just speaking into the void here? Because as the examples show, people will continue to use dignity as they wish to use it, and it does have this baggage, and I'm not particularly optimistic that we can sort of address that in any meaningful way. And what I hadn't really thought about before was the kind of the flip side of that being that actually it almost adds to the messaging power of sexual violence, which is something I found really provocative to think about. So thank you. But again, I will save time for the chat. But amazing comments. Very, very grateful for. I've written pages of notes here. So thank you.
For Anna, I was wondering, do you think the normative concept of sexual dignity would help, for example, jury members when they're determining the culpability of the defendant, of a rape defendant? because as Puja just mentioned, that dignity could be used as a tool for public education. I was wondering if dignity as a concept can help repel certain rape myths.
Yeah, it's a really interesting question because although I don't have, my data set didn't include, for example, jury instructions, and I would probably be quite surprised to see reference to dignity, although I'm sure it's quite common in prosecution addresses and so on. But that broader question about whether dignity is a useful rhetorical framework for challenging prevailing rape myths is certainly something that I did see coming through in the case law. And there were key judgments from various jurisdictions addressing points of development in sexual violence law, which we all know points in time where our law has tried to redress rape myths that are inherent in the system. So, for example, the corroboration requirement or the resistance requirement, rape shield laws. There's instances of all of these sorts of developments in the law saying, hang on a second, there are rape myths inherent in our procedural law and in substantive law, and doing so by expressly tying it to this concern for the dignity of victims, of complainants, the dignity of women. So that's just a short answer, but yeah, absolutely. I think that the idea of dignity and rape myths can be a really kind of productive conversation, I guess.
Thank you. We had a number of questions from this audience. Let's just go through the first one. They're asking, in New Zealand law, what are the criteria for determining what constitutes sexual dignity, whether a woman's sexual dignity has been violated, and what constitutes sexual violence, sexual harassment, and pornography? Here's a bit of
I can see that question. So I think if I scan through it, because I should hasten to add that dignity is not used in the New Zealand Crimes Act. It's just, I noticed in New Zealand case law that it was frequently being used primarily for these expressive purposes. So to try to explain and express what perhaps is inexpressible, the various harms and wrongs of sexual assault. So I didn't notice anything particularly different about the way courts are using dignity in New Zealand. I think that the Māori, kaupapa Māori, so Māori research on sexual violence as a transgression against the community is something that I do reference. I'm not a kaupapa Māori scholar. I don't have a great deal of knowledge, and there's not been a huge amount written on sexual violation as it's conceptualized in the te ao Māori, in the Māori culture. But I did find some really interesting articles which point to dignity, sexual violation as associated with mana. And mana is a really interesting concept in New Zealand law, which I've written separately on with my colleague Mihiata Pirini, and I can send that link out as well, because mana is often translated, it's a Māori word often translated to dignity, but it's not at all the same thing. And of course, that's part of the problem when you're trying to engage with Indigenous research, is these concepts are not translatable. And so the idea of mana is actually, unlike dignity, seen as something that can ebb and flow, and that can be higher or lower in people depending on their status and role in society. So I'd love to learn more about how sexual violence is conceptualized in te ao Māori. But at the moment, there's only a very limited discussion of that in the paper, because it's just simply not my specialty. Yeah. I might leave some.
Yep. Mm-hmm. Actually, the part about Maori culture in your paper is one of the parts that really stood out to me, because it's really not a concept that I've thought of or I know of. So really interesting that you've discussed that.
Yeah, and if I can just add to that, and this goes to a point that Puja made earlier as well, I recognize that I'm taking a very, I'm attempting to, by doing a sort of global review of these Anglophone jurisdictions, I'm already doing quite a lot in this paper, so I wasn't able to engage. And also, you know, as a white New Zealand scholar myself, I didn't feel positioned to engage with different cultural perspectives on the value, the meaning, the conceptualizations of dignity. So there have been really important articles written about, for example, dignity as it's conceived and understood in the Asian cultural context, which I've referenced, but I haven't really tried to go there in this paper. But I do recognize that you can bring different cultural perspectives to questions, particularly such as questions as, you know, dignity and honor, which I think goes back to, it was a generous reading, Puja, and I hope it comes through that I'm not saying that it's unfeminist to conceive of dignity as honor, but that the dominant conception of dignity that was coming through in the feminist theory, English language feminist theory, was certainly that it should be more than honor. And honor alone would sort of raise some troubling concerns about stigmatization, but that's not to say that there's not an important validation of honor, which is the lived experience for many victims as well, that their honor has been assaulted. I think my concern was more that when courts are perhaps arguably not being so careful with their language and begin to describe rape victims as having been shattered or destroyed or irreparably defiled, that the language of honor can be quite othering and potentially harmful.
How should we reconcile, for example, like various feminist understandings of sex workers with the concept of sexual dignity?
Yeah, so I mean, I would disagree that sex work is unethical, but obviously that's just a personal viewpoint, and I think that goes to the potential problem with dignity, right? That it can be harnessed by the majority, the political majority, to be used to trump autonomy. Now, that's a big question, whether that's the role of the political majority, but it certainly raises questions about minority rights. And you might be of the view that using a dignity argument to trump a person's autonomous interest in engaging in sex work, you might be of the view that that's a good use of the dignity rationale, but there are probably other instances where dignity might be used to trump. It could be a very slippery slope, and it does certainly raise questions about whether that's an appropriate function. So I guess my point is that regardless of whether you agree with particular sexual behavior, the fact that we can have a really strong allegiance to the idea of dignity developing in the context of the so-called easy cases where there is pretty much universal agreement that sexually assaulting someone against their will is wrongful and harmful, well, there are implications for our understanding of dignity forged in that context for other trickier cases. Thanks, Cherry.
I think we still have 3 minutes left. If you would like to respond to Puja's comments earlier.
Oh yeah, just one more thing I wanted to say. So I found your discussion of intrinsic and attributed and flourishing dignity really helpful, and then relating it back to this idea of, you know, does it have to be a zero-sum approach? And I think that was something I found really interesting in the cases, particularly as a South African decision, which might be of interest to people in the chat, involving whether protection from sodomy, anal sex as rape should be afforded to women and then also to men. And the majority took what I would say is a fairly zero-sum approach, saying that because rape is a gendered crime, if we're going to extend the definition of this gendered crime to anal penetration, that's fine, that provides better protection for women, but then to provide the same protection for men goes beyond, somehow damages or undermines the recognition of this as a gendered crime that does primarily impact or disproportionately impact women. And I found Chief Justice Langer's dissent to be just a really powerful reminder that we can take a pluralistic approach to dignity. Of course, though, the concern becomes, well, what does that mean for, the actual content and semantic status of dignity? Doesn't it just continue to mean whatever we want it to mean? And maybe it does mean that. I'm not particularly trying to advocate for a dignity framing here. I'm more realistic that it will continue to happen. So I'm trying to contribute to that conversation in some way. But whether that's meaningful in terms of trying to develop or advocate for a dominant conception, I'm not sure. I was really trying to identify what the perhaps dominant conception is that I saw coming through in my literature. But again, I recognize that my literature was quite siloed in some ways, and certainly very much taking a Western focus and approach to the issue. So you could write volumes and volumes about what dignity should mean or could mean or does mean. So this is just one small contribution to that broader conversation. And I was very grateful for the opportunity, as I said, to hear Puja's thoughts and to share it all with you today.
I think that's really helpful as well to sort of articulate exactly where sort of the paper can be situated and sort of the work that you've done. I think that's useful for this particular audience. And I just think that, one of the things that's challenging, I guess, in using dignity here in Asia is, whether we're talking about China or India or some of these other sort of spaces, dignity is inherently a relational concept. And so in that way, it's very hard to pry ourselves away from this idea of dignity being a standalone, inherent sort of facet of a person by virtue of their humanity. And I'm sure that dimension is there, and it can be articulated through various cultural texts or even religious texts as a construct. I think that there is language there similar to how you've identified the mana in the context of the Maori culture. But I think that in legal kind of language, we very seldom see it used because there's this overbearing understanding of dignity as relational societally. And that's where, for me, as my comments sort of highlight, there's this circular impact of the way in which you use dignity and how rape is used, or weaponized rather. So I think that this is really helpful because hopefully it opens up a channel for further exploration of how the work of dignity is evolving in this particular context, or what is the work that remains to be done to see if it can be distanced from or perhaps re-articulated in a way that encompasses the broader cultural connotations underlying this device.
Thank you again to Anna and Puja for the really lovely discussion today.